Welcome to the Business SOS podcast. This is Rich Sierra. This is episode 91 of Business SOS, and we're inching away. Just a few more episodes, so we want to reach episode 100. We're excited about that. So today I want to talk about the most common reasons businesses get sued and how to avoid them. And as you remember throughout the last few weeks in the podcast, I've gone through a lot of topics dealing with litigation. And litigation really, you can have a podcast just dedicated to that, a whole series of them. And I do quite a bit of litigation, so I continue talking about those subjects because it is important. I find out that many business owners do not recognize the potential exposure that they have and sometimes they take some action, some decisions. I want to tell you about some of the common ones that I see, happening very often in my 20 years of practice. So I'll talk about that today. And the objective is to give you some idea and have you recognize areas that potentially you could be sued for. Doesn't mean that you will get sued. You potentially can get sued if you don't take some action, or at least some preventive action, or recognize those warning signs. So let's go into it. Many of the areas that I deal with in my litigation practice, they stem from a contract. In fact, most of the cases that I deal with breach of contract. And it's, I can see why, because usually it's an agreement that two parties make, and somewhere down the line, one party feels the other one did not comply. So I want to tell you some of the reasons why you have breach of contract claims. One of them might be to failure to deliver the product or service as promised. And that's very common. And what I also see when I ask the question, is there a contract? Oftentimes the answer is no. We just agreed to it via text. It was a verbal agreement. We kind of know each other. And I am surprised still in this day and age how easy to develop a contract that many people get into oral agreements. It does not mean that oral agreements are not enforceable. In fact, they are, and there's some provisions how you can enforce an oral agreement. That could be a topic in and of itself. But, from a business standpoint, the best practice is to have a written contract. And within the written contract, then you have other provisions as well, which I've discussed before in this podcast, and perhaps maybe I should revisit the topic about important contract provisions, so that way you keep that in mind. But as I mentioned before, if you're going to draft a contract, you're going to review a contract, is best advice I can give you is to seek the advice of counsel. Get an attorney to help you draft that contract to make sure that you're properly protected. Before you sign a contract, I would advise you, especially if you do not know the subject matter well, you don't know how to read the contract, you're not an attorney, perhaps get an attorney to read it, help you interpret that contract for you, and advise you as to areas that you need to focus on to make sure that you're protected. And many times business owners download contracts from the web. Some of them are really good. I'm not saying that they're terrible contracts. But unfortunately, they contain a lot of boilerplate language that may not be applicable to you. And oftentimes, I see contracts which do not include all the provisions that should be included, specifically in the terms that were agreed upon. So that, is surprising to me. And when I look at sometimes some of these contracts, I say, well, what do you guys agree to do? Is it here? Oh, we kind of put some general terms, but everything else is fine. And I said, well, that's actually the most important part. Exactly what you agree to do for that other individual, what will you be receiving in return? The services, the payment terms, dispute resolution, some of the things that I've covered before, but I'm happy to cover them again at another time. Disagreements between pricing or perceived pricing and service. And what happens is this. Sometimes people agree, okay, I'm going to do this service for you. And that just happens a lot with in home repair and construction type of remodeling type of contracts, where the homeowner and the contractor agree on a price, say whether it's to remodel a kitchen or replace the counter, and they don't talk about contingencies that could happen. If there perhaps some type of plumbing repair or rerouting some type of plumbing, they don't cover that. They don't discuss that beforehand. And then the homeowner gets an extra bill. Hey, listen, we needed to reroute the plumbing here. We needed to do some adjustments to be able to accommodate this countertop. And so, well, we didn't discuss that. So those disagreements are very common when we're dealing with remodeling contracts. It's important to have all those terms laid out in the contract. Ambiguity in contract terms. This happens a lot. When you have the terms are not very well defined, or my favorite quote clause, quote unquote, to be determined in the future. I see that quite a bit, that you have an agreement and they do not really have all the contract terms set up or laid out, but they agree to begin to work together in some type of joint venture, some type of business arrangement, but they're going to determine how they're going to get paid at another time. Those indefinite terms makes it difficult for any attorney to enforce, because one of the questions that will be asked is whether or not the parties had a meeting of the minds, whether the parties actually agreed to do something together with definite terms and definite duration. So those are things important to keep in mind. I also see contracts sometimes that only one party signs and not both parties signs. The and again happens with DocuSign. Sometimes people sign one contract, they start working, the other person forgets to sign it, or you get a signed copy one party, then the other party signs it, they don't have a copy. If you sign a contract, make sure you get a countersigned copy of both parties signing the contract. It's very, very important to do that. And I've mentioned this before. It's important to have a dispute resolution clause in the contract, whether it's arbitration, mediation, court. Those things are important to have there. And I think that now, as I'm talking about this, I'm probably going to do a podcast specifically in contract terms that I suggest should be included in every contract, and at least you have that information with you. Another common lawsuit that employers or business owners receive or get sued for is employment issues. And employment issues are it's a wide range of topics, and I'm going to go over some of them. In fact, I have a podcast already prepared to talk about specific employment issues that may arise later on. But one of the common ones is wage and hour violations, including unpaid overtime and minimum wage violations. And if you recall a couple of podcasts back, maybe about a month or two ago, I went into 1099 and W-2 and quote unquote employees. And I told you, and I said that there's no such thing as a 1099 employee. And in fact, yesterday I was meeting with a client. We're talking about some issue that came up. And I said, well, is the individual an employer or an independent contractor? Well, it's a 1099 employee. And of course I said, well, that does not exist. So I said, tell me specifically, what does this person do? Do they have to show up to work every day? Yes. Do they have to, you supervise this individual? Yes. Okay. Does this person only works for you? Yes. So based on that limited criteria, I said, listen, this individual is an employee. So you have to pay this individual as a W-2 employee. Well, he really wanted to be paid as a 1099. The unfortunate part of this is that it's not to the employee to make a decision how he or she is going to be paid. The employee doesn't get a choice of classification. It is your responsibility as a business owner to have the proper classification for this employee. You decide, you basically classify them properly. So what happens is the following. So you pay this individual 1099, and later on, and then the person is working overtime. You have a falling out with this employee. Then say, you know what, I did not get paid my overtime. Person gets an attorney, and then you can be in the receiving end for a violation of the Fair Labor Standards Act, in violation also for Florida law as well. What happened in this case is that in a federal lawsuit, in this type of statute that is for unpaid overtime or misclassification, it's a pro-employee statute. What does that mean? Mean that if you don't have proper records of the employee's hours and how the person got paid, okay, it is assumed that the allegations made against you by the employee are true. So it is essential for you to make sure that you're classifying employees properly. And don't give the employee an option how the employee is going to be classified, because it is your responsibility, not their choice. It's not a multiple choice exam. You classify them properly. You're also running into another issue here, a more serious one. Just that one is serious. Say this individual is working for you. You have the individual, listen, go ahead and go to Office Depot, because of supplies, if people still do that, but the person doing work for you goes out in an errand for the work. Person gets into an accident. Okay? Then clearly the employee is going to say, yeah, who's your employer? ABC employer. They're going to ask for your workers' comp carrier. Worker comp's going to say, that person is not listed here. They're going to ask you why some person is not listed here. It's not 1099 employee. Well, that person should have been included there. Then instead of the workers' comp carrier covering you, you're running the risk that you will be liable for those injuries. So you're not saving any money by misclassifying an employee and not paying them as a W-2 employee versus an independent contractor. It's just not worth it. You could have potential liability as to, unpaid overtime, liquidated damages, attorney's fees that goes along with it, statutory attorney's fees that the law firm who takes on this case to represent an employee then can seek attorney's fees from you, and the court will grant attorney's fees separate from the money that you'll pay this employee. It's per statute. And even though you have a corporation, you have an entity, that will not protect you under a corporate veil. You will still be liable for those fees individually. So it's just not worth it. Classification is important. And if you have a question about whether or not you should classify an employee, independent contractor, or as an employee, or W-2 employees, quote unquote, just call an employment attorney or your business attorney. You can get an HR consultant to help you with this as well, to make sure that you're doing it correctly. But that's just not a proper way to cut corners, so to speak, or take a short circuit. There are other types of lawsuits that are also important here. Wrongful termination, discrimination claims, workplace harassment and hostile work environment claims. Those are also important to know. They're not as common. I don't see that those very common come in terms of the type of work, the businesses that I represent. Uh, but it's important to know that depending on the number of employees that you have, and it is my opinion, anything over 4 or 5, you might want to get an employee handbook. And you can get an employment attorney to help you draft one, or get an HR consultant to help you draft an employee handbook so you have your policies laid out in terms of pay, discipline, termination, performance evaluations, reviews, all that. It's worth having it. Another lawsuit that this also comes in, that why a business owner can get sued, you're talking customer and product liability lawsuits. Unless you develop a product, uh, you manufacture a product, you could have a potential product liability claim. For example, somebody could, if it's a small item, somebody can swallow it, doesn't have the proper warning. If it's something with electronics, somebody can get burned. So my advice is somebody's manufacturing a product and selling out in the open market is to get product liability insurance. And in fact, we talked about insurance before, but in terms of insulating yourself from potential exposure for lawsuits, is kind of a two-prong approach, or a two-side approach. If you're going to look at a bookshelf, okay, you have your insurance protection, general liability insurance, professional liability insurance, product liability insurance in this case as well. So a business insurance broker can advise you as to which type of insurance to get. But also you have your contracts and your policies. That's the second part of that you have to, at the very least, reduce the likelihood of being sued. You're not going to be 100% insulated from potential lawsuit. The only way you can do that is not being in business. You're dealing with people. The likelihood of being sued is there, as always. Okay? But you can also reduce the probability of that happening by having good contracts, good policies, and also, in the case that happens, have protection, have some insurance protection as well. A common lawsuit that happens to businesses, especially dealing with a storefront or with the public, are premises liability. There's a slip and falls. Those are the ones you see on TV, the attorneys, advertising, have you been injured in an accident, et cetera, and they say no recovery, no fee. Okay, so what happened in this case is that somebody slips and fall in your business. Somebody mopping, there was a wet floor, somebody fell, injured, then contacts one of these attorneys that specializes in personal injury, and then you'll get a letter asking you for your insurance carrier. And under Chapter 627, if I recall, if you receive that letter, you got to provide that insurance information within 30 days. It's a certification of insurance. You basically provide the policy. And their objective here is to see how much coverage you have to sue you, but really the objective is to sue your carrier. And again, that's why insurance is so important. And if you're leasing your space for your business, it is very likely that your landlord requires that already. But there's always to double check, make sure you have the proper coverage. So in that case, you provide insurance information and see what happens. And then you can call your carrier. If you have a potential claim, even if you have not been sued, but you receive a demand letter, for example, at that moment, it is very important that, A, contact an attorney, and number 2, also contact your carrier and make them aware that you have a potential lawsuit. And you got to do that as soon as you're aware of it. The reason for that is that some carriers, some policies require you to notify them within 60 days of the time that you have knowledge of a potential claim. So you want to make sure that you say, you know what, we received this letter. I want to make you aware of it. Here it is. What they'll do is assign a case number for you and monitor the case to see if it goes anywhere or if it gets close. But at the very minimum, you have covered, you have made your obligation pursuant to the policy to provide information to the carrier. And it goes without saying that, common sense prevails here, that if you have a business that deals with the public, maintaining safe premises is very important. So that that's that's your responsibility to make sure that you see any type of hazard, to make sure that it's properly taken care of, so that way nobody falls, nobody gets into an accident. Another common loss that I see is partnership disputes. Um, those are very common, and I've done quite a number of them in 20 years of practice. My take on this is that business owners or partners end up litigating or let them suing each other either when they're making too much money or they're making no money. It happens to be that way. This has been my experience. When a partner calls me, a business owner calls me and say, my partner is suing me, or I want to sue my partner, and a common theme that I see is, they tell me that he locked me out of my bank account. He changed the keys to the business, even though both of us are under lease. He locked me out of the computer. So obviously, those are not good news, but it happens very often. So I said, okay, do you have an operating agreement? Do you have a contract? Half of the time, the answer is no. In fact, more than half. No, we kind of started working together. We don't have a partnership agreement. We do not have an operating agreement. We just do it that way. I said, okay. Who has access to the bank accounts? Well, both of us had access. Now he only wants access. He won't let me in the bank account. Okay. So a partnership agreement will not prevent you from being sued by the other partner. But a partnership agreement will at least establish some guidelines that some conversations have taken place as to how the business is going to be run. And I've seen partnership agreements with one page. I've seen them with 20, 30 pages. So there's no fast and hard rule as to how many pages an agreement should have, a partnership agreement. But there should be some provision specifically that should be included there. And I went over those in great detail at a previous podcast. But it's very common when the partners have differences as to profits and distributions. Is a very common reason why somebody gets sued as a partner. Decisions in business and management responsibilities. One partner perceives that he or she's carrying the weight. The other partner is not doing the work, is collecting money, while the other partner is really working the business. Allegations of fraud or misuse of funds, that is very common. And most of losses that I see, which I represent partners or that I'm suing another partner, there's always sometimes, or most of the time, I'm not going to say always, most of the time you see a fraud claim of some sort, which makes the escalation of emotions very high when that happens. And also when partner says, I want to leave the partnership. I'm done. I want to quit. And I want you to buy me out. The other partner says, well, you can leave it. I'm not going to pay you. Or the business is not as worth what you think it is. And it happens a lot in service business where the asset is the skill of the business owner. It's not something tangible that you can sell or scale, but it happens to be that particular. It's a business that is a service business. So disagreements as to the value of the shares becomes an issue simply because then if that partner leaves, clearly the value of the business will go down. Therefore, the share is not worth that much for me to buy you out. So that becomes an issue for a potential lawsuit later on. Another one that talking about partnerships, I mentioned, the risk of going into business with friends and family members. Happens a lot during the holidays. That people go into business with friends and family, nothing wrong with it, But it's always a good idea to have a partnership agreement in place and have it in place before you do that. And important to clear financial record keeping and transparency between the partners. Have everything open. People have access to all their financial records. That really avoids disputes. Last but not least is intellectual property violations, IP violations. It's a very common lawsuit. And those are like trademark infringement lawsuits, for example, copyright infringements or patent infringement lawsuits. And if you recall, not long ago, I had L.A. Perkins, it's a brand protection attorney. We spoke about trademark litigation, talk about trademark protection. And not long ago, I had my friend John Risby as well, that he's a patent attorney. He's known as the patent professor. We spend a great deal of time talking about patent law as well. But it's very common, more common than patent. I see, trademark disputes. One party feels that his trademark was violated by someone else. They sue. They send a cease and desist letter to my client saying, hey, I've been using this trademark for a while, since 2010, for example. I noticed that you're using a trademark that's similar to mine. I need to stop using it. If you don't use it, we're going to sue you. So that's a very common reason why business owners get sued. If you use a brand, first I recommend you go back to this podcast that I spent a great deal talking about podcast, the one with L.A. Perkins and also with the one from John Risby. If you are marketing your brand, it is important that when you use the brand, that you know that you have the right to use the brand and that you're not infringing on somebody else's brand mark. Because you're going to spend a great deal of time, effort, and money, not only in collateral material, business cards, pens, website, everything about your business is going to be known by that brand. To find out later on that you're infringing in somebody else's brand, and then you got to remove that and start all over again building that goodwill. And that brand is an asset for you. You build that brand for a number of years. Somebody wants to buy your business. They're going to say, where's your trademark registration? Do you have one? Even though you have the right to use your mark without trademark registration, you have common law trademark rights, it's a good idea to have it anyway. And, attorneys that specialize in trademark registrations, and you can go to them. LA is one of them, so is John Risby as well. Copyright material as well. I'll give you examples. Like say you go on the web, you want to develop a website, or you want to develop an app, or put something in Instagram, and you find a picture on the web, you download it, even though it's royalty-free, quote unquote, and you use it. You begin to promote it in your business. Perhaps you're a restaurant, you put it in your menu, but you don't know where the picture came from. It just came from the web on the free royalty site. Well, then you get a letter from someone telling you, this is our picture. I mean, unless you took the picture, it is not yours. Just be clear. If somebody else took that picture. The same thing with a drawing, same thing with any type of graphic. So you have two out. You can either you create it yourself or you purchased it from someone or somebody gave it to you for free. So it's a different conversation. But if you're going to use something commercially, if you're going to go ahead and start using something to promote your business, be absolutely certain that you have the right to use that picture. Okay, the best way to do it is buy it. iStock.com, you can get a picture for $12. In some places, even less. So just be safe. And also, if you use a web designer to help you or somebody using collateral material, preparing collateral material for you, brochures, business cards, using any type of graphic, ask them, where did you get this graphic? Where did you get this picture? Because it is important to know where they get it, because even if somebody else got it for you, you still might be liable for it. Copyright infringement litigation is very expensive. It's federal court only. The damages can be in the hundreds of thousands of dollars. It's just not worth it to save a few dollars or be careless about it when it comes down to your brand identity and the brand and how you promote yourself. So even if you delegate it, you still have to be responsible how they get the material. It's very important. We also talk about patent litigation, somebody infringing a patent, and we went over that with John Risby a few weeks ago, but that's not only a common lawsuit. And trade secrets. Trade secret litigation, obviously you don't register a trade secret because it's what it is. But an example of trade secret is your customer list. And I've had situations where one of my clients calls me and says, listen, my employee left, was a key employee. She took all my client list. She can start a brand new business with this. So clearly we take measures to try to get that information back or make sure it's deleted or not used. But the best way to protect a trade secret is exactly that, protect the trade secret. That information has to be on a need-to-know basis. Not all your employees need to have access to everything, but that's a very common lawsuit that employers receive, or also they sue for protecting the intellectual property, a trade secret. An example also is if you have an employee that comes in, work for you, say somebody in the type of sales, and he was working for a competitor. No non-compete agreement, can work anywhere, but that employee brought with him the list of your competitor to begin to source and try to prospect. The competitor finds out, you will be in the receiving end of a lawsuit for conversion of intellectual property. So you have to be careful that when you source your list, it has to be yours and yours alone. And if you're going to purchase a list, make sure that it's not a list that somebody else owns that cannot sell. So I just want to make you aware of that. So to recap, some of the common losses we talk is contract disputes, customer and product liability, partnership disputes, and intellectual property disputes. Those are 5 of the common ones that I see coming my way. Of course, there are many other ones as well, but these are the ones that are most common. If you have any questions about anything that I talked about today, please send me an email at rich@richsierra.com. You can also call us at 866-842-5202. If you want to learn more about legal services, my website is Florida Small Business LegalCenter.com. Remember to follow us at Apple Podcasts, Spotify, or wherever you enjoy your shows. Remember that my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, is available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. My name is Rich Sierra. Until next week, remember that my goal is to help you succeed.